because that's what Jennifer endured. 4 days in that apartment, defecating and urinating in a bucket. That's torture. And we set that apart by these aggravators. We talked a little bit about different types of crimes. We talked about a bank robbery, right? And I talked a little bit about a drive-by shooting. And I said to you that drive-by shootings happen. An altercation occurs somewhere else. People argue. They over gambling or drugs or whatever it is. And then somebody comes back and retaliates at a later date or later time, shoots somebody in their front yard, and a drive-by shooting occurs. That's a first-degree murder, right? And so the reason that we have aggravators and the reason you're contemplating the death penalty in this case is because not all murders are the same. And again, I told you in the beginning, drive-by shootings are a scourge to our community. They cause wreckage and havoc among people and lost lives and whatnot, but it's different here. This homicide is different than a drive-by homicide because you don't have aggravators in that kind of case. You think about somebody who's shot in their driveway. Yes, it's horrible, it's terrible, but there wasn't no torture. There wasn't going to be any mutilation of anybody's body in a drive-by. There isn't going to be a substantial role that a person played in a felony to get them to the homicide like we're going to talk about in a second. And there wasn't a homicide occurred to avoid an arrest. Those are the four factors that we're talking about in this case. We're talking torture, substantial role, avoiding arrest, and mutilation. None of those occur in a drive-by type situation or even in a bank robbery situation that we talked about when the state has to deal with co-defendants, when multiple people commit felonious acts. So that's what distinguishes this crime from others, and that's why we have to prove the aggravators in this crime and why he deserves death. Because of these aggravators. And this one is the dump truck, full of weight. And I'd asked you to sign it, that he tortured her, that they tortured her. The next factor the state was relying on is the murder. Not him, but the murder itself was committed for the purpose of avoiding or interfering with a lawful arrest or prosecution of the defendant or another. And you think about over the 4 days how things developed as they were involved in the torture that they did upon her, all the physical and mental pain. You think about how that progressed. It went from the point where, she is really seriously injured. At this point, they can't let her go. At this point, they're going to have to keep plying her with pain medication, which is, that's their pain medication. At some point, you have to believe that in their minds, they realized they could not let her go. And they could not let her go because of the consequences of what they had already done. And I want to remind you of what the defendant said when he was questioned by Mike Ewer about why he chained her up. Why'd you bring her up in the bedroom and chain her up? What was that all about? And he said that he couldn't let her go after what had happened. Couldn't let her go after what... This is over just the baseball bat incident. When he claims that she was struck by Rebecca Dishman with a baseball bat, he couldn't let her go then after what had happened. And so the logical conclusion, the next step is after the next 4 days where they're just abusing and raping and defiling her person and mentally abusing her, certainly they couldn't let her go. Why? Because they would face consequences for that. Arrest, prosecution. Exactly what this aggravator is about. And as far as the application of it, the weight that you put on it, that's up for you. That's the province of the jury. That's what you're here for. That's what you do. And so you'll take that weight and you'll add it onto the pile of gravel that's already here in the courtroom. For factor number 2, because the state only needs to prove one. The judge will instruct you on the law on that. But factor number 2, that you'll pile that onto that load of gravel. And you think about other reasons why, the other things, actions that they did, think factually what to avoid the arrest. You remember he got rid of the murder weapon, right? He got rid of her belongings, her clothing, whatever she brought there with her, burned. Backpack, I think, maybe, of her belongings. But all those are mindful of the fact that they were avoiding the consequences of their confinement of her and their torture of her. And so that factor, that second factor, will add them on. The third factor the state has elected for you to consider is that the murder was committed while the defendant had a substantial role in the rape or kidnapping. Okay? Different from what you read in your original instructions, in that you've already found him responsible. Because you found him guilty for first-degree felony murder, that he is responsible, that he is part and parcel of the original felonies of kidnapping and rape, and the killing occurred during the commission of that. So you've already found that. This factor is if he had a substantial role in that. And you think about the role he took in the kidnapping and whether or not it was substantial. He did it. He started the whole ball rolling. Right? He found her. He isolated her. He knew her from the Pine House. He's the one who selected her for the purpose of bringing her back to Oak Ridge. And so it's his conduct that we're even here, to even bring her to Oak Ridge. He admits putting the chain around her neck. He raped her. And we can't forget, obviously, that he went and rented the freezer. He continued to keep her from her family for 8 months, moving the freezer upstairs and denying his responsibility when confronted. All of that goes to whether or not he had a substantial role in the underlying felonies, which are the rape and the kidnapping. And I would argue to you that you could put significant weight on that he was the role. That Rebecca Dishman was sitting at home waiting on the prey, so to speak, to be brought to her. And he did. And he had a substantial role. And so that third factor, you'll take that aggravating factor and you find it upon a reasonable doubt, and you'll put a weight on that, and you'll put it up on the pile with the dump truck and the second aggravator, and you'll throw more weight on the pile. And then we get to the fourth factor that the state is relying upon. And like I said, in a drive-by shooting, these things don't occur. That's why this is a death penalty case. That the defendant knowingly mutilated the body of the victim after death. And folks, that you have seen the evidence of that. You heard Dr. Malusinik talk about the types of cuts that they look like they were intentionally done. You know that he removed that body from, and let me back up a little bit, and is putting a body in a freezer in a master closet, some sort of mutilation, knowing that it's going to change its composition in and of itself, much less the cuts and the removal of parts and the nose and her areola and the parts that had to be removed from the side of the freezer when they were freezer burnt. That's mutilation. And so you'll take that mutilation that you know has been proven, obviously as a jury, take it as an aggravator and throw it on the pile. And then you'll look at the mitigators. He had a bad childhood. And you're going to put weight on that. And you're going to put it on the scale against the mountain of gravel that dump trucks had to bring in here. and weigh the two. And if the state has proven based on those aggravators that they outweigh the mitigators, then you shall impose death. And that is a profound thing for me to ask you to do. I know that, and I don't take it lightly up here saying that to you. A difficult thing to ask, but it's following the law. And a verdict in this case of death will be showing him mercy. Be showing him mercy. The only thing he did mercy-wise for Jennifer was to put some drugs in her and torture her for 4 days. The state would put drugs in him, and he'd nod off. Far more merciful than what he did to Jennifer Paxton. Sentence him to death.
Thank you. Defense?
Yes, Your Honor. Bear with me a minute. We'll move this podium.
Yes, sir.
Throw my paper on the floor at the same time. Well, the state is once again arguing a lot of they talk. They did this, they did that, which is fair. But I don't know that it corresponds with the verdict that you returned yesterday on many of these charges. We have acknowledged the tragedy in this case, and it is a tragedy. It's horrible what happened to Jennifer Paxton. It sounds like from hearing all the evidence in this case that it was a lot of broken people that were harming themselves and harming each other. As I said before, we're not here to assign any kind of blame or shame to Ms. Paxton. But it seems like she had her own struggles and demons in life that she was dealing with. But that's no excuse for what happened. I mean, it's awful. And I'm not here to minimize what was done to her in that apartment. But at the same time, in reaching your verdict today, you cannot just lump them in together. You have to separate them and make a particularized finding to elevate and necessitate and justify a sentence of death in this case. And you'll see in these jury instructions the court's going to give you what additional things was Sean Finnegan doing beyond that necessary to have committed these crimes to justify a sentence of death. Again, I would just point out, as I did in opening, he's not ever going to get out of jail again. He's going to be in chains and locked up for the rest of his life. So is Ms. Dishman. So as we go through this, we're going to talk a little bit about the legal principles. We're going to go back through some of his social history. I know we just heard it a moment ago. But I want you to keep in mind, and the court will instruct you on the proportionality between the two of them, Dishman and Finnegan, in reaching your verdict. What is fair? Because it seems to me, in trying to read the tea leaves and analyze and draw conclusions from your verdict yesterday that your decision was that Mr. Finnegan was less culpable in the sense of premeditation in this case. And we've heard in this trial from the only person that's been convicted of premeditated first-degree murder. She sat right there. And it seems that some of her testimony, most all your decision to make as jurors, was incredible. So once again, we acknowledge your verdict in this case. Sean Finnegan, as it stands right now, based on the felony murder conviction, will be held accountable for what has occurred. He will spend the rest of his natural-born life in the custody of the Tennessee Department of Corrections. Again, your decision is whether or not he should be sentenced to death. And from a mechanical application, we do have to talk about the legal principles at issue here, which are the application of the state's aggravating circumstances and the defendant's mitigating circumstances. The judge will instruct you that you have to find each of the state's alleged, in their allegations, each of the state's alleged aggravating circumstances beyond a reasonable doubt, and you have to find that it outweighs all of the mitigation presented beyond reasonable doubt. Again, aggravating circumstances are a reason to kill. Mitigating circumstances are a reason to live. So in considering the state's aggravating circumstances, you all, as a court will instruct you, have to reach a unanimous decision. You all have to agree that they apply. For mitigation, there's no such burden on us. You all do not have to unanimously find that the mitigating circumstances should apply in this case and how much weight to give them. There are 12 of you sitting up there. Okay, you have to deliberate. The court's instructed you. You've already done that. You have to continue to deliberate and work as a group, but you're also, each of you, a jury unto yourself, individually. And the state talked about common sense and the guilt and innocence phase, but each of you comes to this jury and serves on this jury and was selected to be on this jury because of who you are, because of your walk in life, your individual moral compass, the things that you've experienced, the trauma, the good things, the victories, the defeats. There's a reason why you're here and why you were selected to be here, and you don't leave that at the door. And as you sift through the evidence in this hearing and the evidence from trial, which you're supposed to consider all of this in reaching your decision, as you sift through it, each of you can decide on your own, for whatever reason, to apply weight to a given mitigating circumstance. And that doesn't have to necessarily be for, as the state paraphrased, bad childhood, okay? Sure, we're going to talk about this some more. I'm not going to go through it all. But it could be for other fundamental principles that we all live with, such as mercy or sympathy. And as I stated, it can be anything. And my point is, if you reach a decision in this case, you don't have to violate that decision if someone else disagrees with you. The court will encourage you to deliberate and work amongst yourselves, but I'm here to tell you, you're here for a reason. We wanted people that came from all walks of life and that have strong personalities, and we want you to continue to be strong. We want you to continue to be an individual and speak your mind if you want to, but you don't have to. The state has alleged several aggravating circumstances in this case. Again, a lot of the use of the word they. I would encourage you to try to split apart Mr. Finnegan from Ms. Dishman as you go through these. as to the so-called torture or serious physical abuse. I spent a lot of time working late last night trying to understand this in relation to your verdict, and I don't think it's very easy, but you came back with a verdict of attempted aggravated rape as to count 4, and not guilty as to count 5, but guilty as charged as to count 6. So my takeaway from that is that you all struggled with a very violent and horrible situation. I'm not minimizing that, but it's not crystal clear and evident what exactly was happening in that room. And oh, by the way, the state keeps talking about 4 days this and 4 days that. To me, that sounds like it came from Mr. Finnegan's statement. So Ms. Dishman had a different timeline, if we're going to go back and talk about Dishman's several recollections about timelines. But I think the point that I'm trying to make is that you need to try to split apart Mr. Finnegan from Ms. Dishman. And as it relates to torture, you need to think that's not just that torture was inflicted, it is what was inflicted beyond that necessary to produce death. Serious physical abuse, what was inflicted beyond that necessary to produce death? I think the blunt force trauma that Ms. Paxton suffered on her shoulder and arms from the bat, that incident occurred early on in that process. That wasn't going to produce death. I think the medical examiner talked about that. The cause of death was strangulation, and you saw the ligature on her neck. What beyond that did Sean Finnegan do to either torture or cause serious physical abuse? As it relates to kidnapping, again, I'm not here to minimize what Sean's actions were, but the physical act of chaining her, that was to accomplish the kidnapping. That wasn't above and beyond what was necessary, and it certainly didn't produce death in that circumstance. The avoiding or interfering with under Section 6 of the aggravators, that's where you have to ask yourselves, what was the motivation? What was the motive? Why did Sean do that? Well, you all returned a lesser included offense on premeditated first-degree murder of criminally negligent homicide. You acquitted him of conspiracy to commit first-degree murder. Ms. Dishman has been convicted of both of those offenses voluntarily. She pled guilty to them. So to me, that signifies that you believe that Ms. Dishman had some more responsibility for causing the murder. Felony murder is relatively straightforward, and again, we've accepted that verdict. But from my reading of your verdict as it relates to Sean Finnegan's culpability for committing first-degree murder by premeditation, I think the evidence shows that it was Rebecca Dishman who was driving that bus. That, once again, this horrible chain of events happened in the house, and Mr. Finnegan went to work. And he came back, and Ms. Paxton had died. That doesn't sound like there's proof that Mr. Finnegan intentionally killed her to avoid arrest or prosecution. On the felony murder aggravator, that's what he's convicted of, as charged. That conviction alone cannot serve as grounds to find that aggravating circumstance. You have to find something more in the evidence. The state wants to talk about he was the role. And with all due respect, they're going back and they're relitigating this prey theory, which I think was not in evidence and is not reflected in your verdict. As to the mutilation aggravator, I would just say that Sean Finnegan has been convicted of both tampering with evidence and abuse of a corpse. you all convicted him of that. He's going to be held responsible for that and punished for that. The only thing I would say is even the medical examiner could not tell us when the body was mutilated in that 7-month period and by whom. Again, you must make a particularized finding as to Sean Finnegan so that it's elevated because the punishment is so severe. Now, we have filed and we have presented mitigation in this case. I'm not going to rehash all of that testimony. I think it speaks for itself. We appreciated Roxanne Mundy being here, but I think it's important for you all to know about Mr. Finnegan, where he's from, how he grew up, and the trauma that he received, and basically how it affected him as he became a young adult and an adult. From a legal standpoint, there's a few takeaways I want to leave with you. Once again, you all get to decide the weight to give both the aggravating circumstances and the mitigating. You don't have to follow this mechanical operation of a set of scales, dump trucks, pebbles, rocks, boulders. I think it's a good physical analogy, but it doesn't encompass the gravity of the decision that you've got to make in this case. We're not pulling a lever here. You can think about things like pity and mercy and sentiment and sympathy. And each of you individually can be the sole judge of whether one of these factors exists and how much weight to get it. And again, we don't have a burden of proof on our mitigation. The state has to disprove our mitigation beyond reasonable doubt, and that's all of it. So our mitigation, as you'll see in the instructions, deals with his background, much of it his social history, his employment history. He's worked for about 40 years. In our estimation, allowing him to go to prison to serve out the rest of his years. He potentially could work in prison. You've seen his demeanor throughout this case. Pretty low-key guy, stay out of the way, not cause any problems. That's Sean Finnegan at this stage in his life. Is it sad? Is it pitiful, pathetic? I mean, he's been sitting out the Anderson County Jail for 4 years, waiting for trial in this case. His life is effectively over, but we think that he can go on and still function and be helpful. He has job skills, and you heard from Ms. Mundy and Ms. Miller that he's a reliable guy, he's dependable, and he's a hard worker. And we think that counts for something. Now, the other mitigation, his social history, his life, it's pretty brutal stuff. It doesn't sound like he or many of the other kids really got a decent start at life. Dropped out of school in the 8th grade, low education, functioning, but low education, and suffered sex abuse, physical abuse, verbal abuse. Not a pleasant childhood, but I think the takeaway is that he endured. He survived. He didn't have a lot of network or services available to him, but he survived and did the best he could. We're talking about the late 1970s into the 1980s. It's not the same as it is today. And eventually he moved to Tennessee, and he brought Frances Finnegan with him because it sounds like there wasn't room for her at the other siblings' houses, and he took care of her, and they lived together. I know it's kind of a bizarre side issue to this case that Frances Finnegan was living in that apartment the whole time, but she did pass away. But the takeaway I think that's important is that despite all this brutality and carnage and disrespect of another human being, that somewhere, somehow, Sean Finnegan does have love in his heart, and he took care of his mom. until he came to jail, and then she passed away after that. So beyond the mitigating factors, which I believe we have proven beyond a reasonable doubt, and which I think are enough to outweigh the state's aggravating circumstances in this case, the last major issue I want you to consider, and then I'll sit down, is proportionality. Is it fair? Based on my reading of your verdict, as it relates to premeditated first-degree murder, you came back with a very low lesser-included offense, and you acquitted him of the conspiracy count related to that. Rebecca Dishman is guilty of those counts, and she's going to prison for the rest of her life. And in exchange for her testimony, her death notice was withdrawn by the state of Tennessee. The way I see it, is it fair for Sean Finnegan to receive a sentence that is greater than Rebecca Dishman's? That he should be put to death? When you all have sat here for a week and evaluated this case under the law and found that he is less culpable than her for the premeditation angle in this case, he should be put to death? I mean, it's horrible. We're not here to minimize what has happened, but I get the feeling that some of you, maybe all of you, tend to agree that maybe Ms. Dishman had more to do with this than the state has been arguing and that the state tried to present in this case. So we do not think it would be fair. It would be disproportionate for Sean Finnegan to be put to death when Rebecca Dishman was the one that strangled Ms. Paxton in the floor of that apartment. People with limited intelligence are probably susceptible to domination and manipulation. I think that's probably fair, maybe for both Ms. Dishman and Mr. Finnegan. People that have prior sex abuse are predisposed to sex activity that most of you would find depraved. I think that encompasses the negative parts of Sean Finnegan's early life and perhaps explains, in part, why we are all sitting here talking to each other today. But at the end of the day, as I told you in my opening statement, the law recognizes a life sentence. Okay? That is a legal sentence. It is a lawful sentence. And it is a proportional and fair sentence in this case. And so we ask that when you go back there, this is an awful decision that you have to make. It is an awesome decision that you have to make. I think that when we think about voting anymore, I think it's easy to be cynical about how much weight our votes count in the political process. Well, this will be the most consequential vote that each of you is ever going to cast. And I don't think there's anything you have to worry about Sean Finnegan ever getting out of jail again. We think it's appropriate to allow him to die naturally in prison. So we ask you to vote for life in this case. Thank you.
Thank you, counsel. And for the state?
Thank you, Your Honor. We can talk about what's fair, but unfortunately in this situation, fairness has very little that we can weigh on here, because what is fair is if Jennifer Paxton were still here. And so what justice is in this case is the maximum penalty for Mr. Finnegan for what he and Ms. Dishman did to Jennifer Paxton. Premeditation is sort of a red herring here. We're not asking impose the death penalty on count one, and that was the premeditation count. These aggravating factors that the state has set before you are to counts 2 and 3 only. And so those are the felony murder counts. And so whose idea it was, who planned it, isn't something for consideration on this, because you as the jury have weighed that evidence and decided that count 1 was off the table, frankly, for this sentencing portion of this case. And so the state submits to you that we have proven beyond a reasonable doubt through the course of this trial each and every one of those aggravating circumstances. And we submit to you that any one of those aggravating circumstances far outweigh the mitigation proof that's been put in front of you today. And we do not in any way believe that this is an easy decision. When you were selected for the jury, each of you did say you would meaningfully consider, because that is the baseline to look at the evidence and weigh it very carefully. It is a great and heavy responsibility to weigh these factors. But the state believes that when you do and you consider the proof, that each one individually outweighs the mitigation, and together those factors far, far outweigh the mitigation, and that the just sentence here for Mr. Finnegan is the maximum allowable by the law. There's question about what's fair or what the difference is between Ms. Dishman and Mr. Finnegan. The reason that we know about this is because Ms. Dishman disclosed. The reason that Ms. Paxton's family was able to end their search and get the answers, regardless of how horrible those answers were, was because Ms. Finnegan disclosed, implicating herself in that and accepting the responsibility for it. To contrast it, Mr. Finnegan continued to deny until presented with irrefutable proof, and then made some concessions. By his own statement, he was actively engaged in the kidnapping, in the cover-up, in all of this, far beyond, and you've heard the proof, but beyond what was necessary for the crime. So when we talk about, well, there were these bruises or these hits or these cuts, and those didn't cause death, that's what we're talking about. None of those were necessary to cause death. And one choking incident could have caused death, but we have at least 5 ligature marks. And as General Allen said, it does not matter which individual committed each of those ligature marks, each of those strangling. They are in it together, and they convicted of. He was convicted of the conspiracy. He was convicted of the felony murder by kidnapping and the felony murder by rape. He is part and parcel of all of this. He had the opportunity every single day to leave and intervene. He was going to work, acting casual, joking around, apparently. And yet, his cover-up continued of it. You've heard the proof. Again, this has been an arduous task and lengthy, and so I will not belabor every bit of evidence that you have already heard, but would reiterate that for the actions that were done to Ms. Paxton, for the torture that she endured, for the mutilation to her body, which we know was done by Mr. Finnegan. He had to cut her out of the freezer. There was freezer burn on that. She was stuck to the freezer, according to the medical examiner. We know he was engaged in that, and freezing does change the body. Both of these things that you know irrefutably that he did, that he told you he did, support the mutilation. And the mitigating factors do not outweigh the aggravators here. Justice for Jennifer Paxton is the maximum sentence in this case. And we ask you to meaningfully consider this proof and the aggravators and the mitigators, and we will ask you to impose the maximum sentence. Thank you.
Thank you. Jeff, if you could hand out these jury instructions to our jurors, I think there's 14 there, I hope. All right, I think each one of our jurors have a copy of the jury instructions. Let me review those documents with you. Members of the jury, you've now found the defendant guilty beyond a reasonable doubt of murder in the first degree as charged in indictment number C1C00518. It is now your duty to determine within the limits prescribed by law the penalty which shall be imposed as punishment for this offense. Tennessee law provides that a person convicted of murder in the first degree shall be punished by death, by imprisonment for life without the possibility of parole, or by imprisonment for life. A defendant who receives a sentence for imprisonment for life shall not be eligible for release until that defendant has served no less than 51 full calendar years of such sentence. A defendant who receives a sentence of imprisonment for life without parole shall never be eligible for release. Each of you must decide the case for yourself, but you should only do so after discussing the evidence and instructions with your other jurors. In arriving at this determination, you're authorized to weigh and consider any of the statutory aggravating circumstances proved beyond a reasonable doubt, and any mitigating circumstances which may have been raised by the evidence throughout the entire course of the trial, including the guilt-finding phase or sentencing phase or both. Mitigating circumstances do not have to be proven beyond a reasonable doubt, but rather they are considered if raised by the evidence. The jury is the sole judge of the facts, and the law applies to the facts in the case. In arriving at your verdict, you are to consider the law in connection with the facts, but the court is the proper source from which you are to get the law. In other words, you are the judges of the law as well as the facts under the direction of the court. The burden of proof is upon the state to prove any statutory aggravating circumstance or circumstances by reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case and inability after such investigation to let the mind rest easily as to the certainty of your verdict. Absolute certainty is not demanded by the law, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the verdict. The law makes you, the jury, the sole and exclusive judge of the credibility of the witnesses and the weight to be given to the evidence. The prosecution has introduced what is known as victim impact evidence. This evidence has been introduced to you to show the financial, emotional, psychological, or physical effect of the victim's death on the members of the victim's immediate family. You may consider this evidence in determining an appropriate punishment. However, your consideration must be limited to a rational inquiry into the culpability of the defendant, not an emotional response to the evidence. Victim impact evidence is not the same as an aggravating circumstance. Proof of an adverse impact on the victim's family is not proof of an aggravating circumstance. Introduction of this victim impact evidence in no way relieves the state of its burden to prove beyond a reasonable doubt at least one aggravating circumstances which has been alleged. You may consider this victim impact evidence in determining the appropriateness of the death penalty only if you first find that the existence of one or more aggravating circumstances has been proven beyond a reasonable doubt of the evidence independent from the victim impact evidence. and find that the aggravating circumstances found outweigh the finding of one or more mitigating circumstances beyond a reasonable doubt. Statutory aggravating circumstances. Tennessee law provides no sentence of death or sentence of imprisonment for life without possibility of parole shall be imposed by a jury but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more of the statutory aggravating circumstances, which shall be limited to the following. 1. The murder was especially heinous, atrocious, or cruel that involved torture or serious physical abuse beyond that necessary to produce death. 2. The murder was committed for the purpose of avoiding, interfering with, or preventing a lawful arrest or prosecution of the defendant or another. 3. The murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting to commit, or was fleeing after having a substantial role in committing or attempting to commit any rape and or kidnapping. Knowingly means that a person acts knowingly with respect to the conduct or circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it's the person's conscious objective or desire to engage in the conduct or cause the result. 4. The defendant knowingly mutilated the body of the victim after death. Knowingly has been defined in subsection 3. Refer to that definition herein. You're instructed that the word heinous means grossly wicked or reprehensible, abominable, odious, or vile. Atrocious means extremely evil or cruel, monstrous, exceptionally bad, abominable. Cruel means disposed to inflict pain or suffering, causing suffering or painful. Torture means the infliction of severe physical or mental pain upon the victim while he or she remains alive and conscious. Members of the jury, the court has read to you the aggravating circumstances which the law requires you to consider if you find proof beyond a reasonable doubt. In order to consider any aggravating circumstance or circumstances in your sentencing determination, all 12 jurors must unanimously agree such circumstance or circumstances have been proven beyond a reasonable doubt. You shall not consider any other fact or circumstances as an aggravating circumstance in deciding whether the death penalty or imprisonment in life without possibility of parole would be an appropriate punishment in this case. If you unanimously determine one or more aggravating circumstances have been proven beyond a reasonable doubt, it is then each juror's individual determination as to how much weight any such aggravating circumstance should be given in weighing the aggravating circumstance with any mitigating circumstance. Mitigating circumstances. Tennessee law provides that in arriving at any punishment, the jury shall consider, as previously indicated, by any mitigating circumstances raised by the evidence which shall include but are not limited to the following. A, any residual doubt as to defendant Finnegan's guilt, which may consist of any proof or evidence which indicated defendant Finnegan may not have committed the offense, notwithstanding the jury's verdict. 2, any evidence defendant Finnegan was raised in an unstable and volatile home environment, including evidence he lived with his family in a vehicle as a young child. 3, any evidence defendant Finnegan's father was an alcoholic who exposed defendant Finnegan to seeing his father repeatedly, physically and emotionally abuse his mother throughout his childhood and adolescence. 4, any evidence defendant Finnegan was raped, sodomized, prostituted, and sexually exploited as a child while in the care of his extended family member. 5, any evidence defendant Finnegan experienced emotional instability. 6, any evidence defendant attempted suicide at the age of 16. 7, any evidence the defendant Finnegan attempted to self-medicate and treat his depression with the use of alcohol and drugs. 8, any evidence defendant Finnegan only had an 8th grade education. 9, any evidence defendant Finnegan has the work skills enabling him to be productive in state custody. 10, any evidence of the sentence received by the co-defendant Rebecca Dishman, who testified in this manner. And 11, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing, that is, you shall consider any aspect of the defendant's character or record or any aspect of the circumstances of this offense favorable to the defendant, which is supported by the evidence. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance, or that you agree on the same mitigating circumstance. If you individually determine one or more mitigating circumstances have been raised by the evidence at either the guilt or innocent phase or the sentencing phase of these proceedings, it is then each juror's individual determination as to how much weight any such mitigating circumstance should be given in weighing the aggravating circumstances with any mitigating circumstances. The defendant is not taking the stand to testify as a witness during the sentencing hearing, but you should place no significance on this fact. The burden is on the state to prove, one, any aggravating circumstance or circumstances beyond a reasonable doubt, and two, that the said circumstances or circumstances have been proven by the state to outweigh the mitigating circumstances or circumstances beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such a fact. If you do not unanimously determine that the statutory aggravating circumstances have been proved by a state beyond a reasonable doubt, the sentence shall be life imprisonment. You will write your verdict form in enclosed verdict form hereto and made a part of this charge. The verdict shall be as follows. We, the jury, unanimously find that the punishment shall be life imprisonment. If you unanimously determine that a statutory aggravating circumstance or circumstances have been proven by the state beyond a reasonable doubt, but that such statutory aggravating rape or circumstances have not been proven by the state to outweigh any mitigating offense beyond a reasonable doubt, you shall in your considered discretion sentence the defendant either to life or to imprisonment for life without possibility of parole or imprisonment for life. In choosing between the sentence of imprisonment for life without possibility of parole and imprisonment for life, you shall weigh and consider the statutory aggravating circumstances or circumstances proven by the state beyond a reasonable doubt and any mitigating circumstances or circumstances. In your verdict, you shall reduce to writing the statutory aggravating circumstance or circumstances so found, and you shall return your verdict upon the closed form attached hereto and made a part of this charge. The verdict should be as follows. We, the jury, unanimously find that the state has proven the following listed statutory aggravating circumstances or circumstances beyond a reasonable doubt. We, the jury, unanimously find that such statutory aggravating circumstances or circumstances do not outweigh any mitigating circumstance or the circumstances beyond a reasonable doubt. Therefore, you shall then indicate on the clear verdict form either we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without possibility of parole, or two, we, the jury, unanimously agree the defendant shall be sentenced for imprisonment for life. The verdict must be unanimous and signed by each juror. In regard to death, the verdict for death. If you unanimously determine that at least one statutory aggravating circumstance or several statutory aggravating circumstances have been proven by the state beyond a reasonable doubt, and said circumstance or circumstances have been proven by the state to outweigh any mitigating circumstance or circumstances beyond a reasonable doubt, the sentence shall be death. The jury shall reduce to writing the statutory aggravating circumstances or statutory aggravating circumstances so found, and signify the state has proven beyond a reasonable doubt that the statutory aggravating circumstances or circumstance outweigh any mitigating circumstances. You will write your findings and verdict forms in enclosed forms attached hereto and made a part of this charge. Your verdict shall be as follows. We, the jury, unanimously find the following listed statutory aggravating circumstances or circumstances beyond a reasonable doubt. You will then write out which statutory aggravating circumstance or circumstances you relied on. Next, we, the jury, unanimously find the state has proven beyond a reasonable doubt that the statutory aggravating circumstance or circumstances so listed outweigh any mitigating circumstance, and therefore we, the jury, unanimously find that the punishment shall be death. The verdict must be unanimous and signed by each juror. It's important that you take the case and consider all the evidence fairly and impartially and complete one of the three verdict forms and report your verdict to the court. And here are the three verdict forms here. that I'll give to you to go back and consider. We had one exhibit, so I'm gonna give you that one exhibit as well to take back. Our plan for the rest of the evening is, I'm gonna let y'all work till about 5 or 5:30, bring your foreperson in and ask if y'all wanna keep working or you wanna call it a day and come back tomorrow. And that's really solely up to y'all. Whatever your decision will be is fine with us. So it's just kind of your call on that. When you do reach a verdict, if you'll just knock on the door and tell one of the deputies that you have in fact reached a verdict, then we'll bring all of us in together and then we'll determine, and then we'll announce the verdict from there. Everybody understand that? Anybody got any questions? Okay, let me give that to you. Give them the verdict form and the one exhibit. All right, everybody rise, please.
Judge,
I need the alternates to stay here.
you said you wanted to tell them to remind them that if they have any kind of a question, just.
Thanks, I forgot that. If y'all have any kind of question, like we did last time, be sure you write the question out, and then sign it, the foreperson needs to sign it, put the time, because I have to keep up like 1, 2, 3, 4, how many questions there are. So be sure you do that. All right, okay, see y'all in a few minutes. See you when it's deliberated. Thank you. You go ahead and take those two, and then come back and we'll take care of our alternates. Take them, yep, jury first. Thank you. Have a seat. Y'all can have a seat too. So my two alternates. The laws in Tennessee, once they start deliberating on a punishment, then that's it. So if they get sick or sometime under, I gotta do it over again. So hopefully they won't do that. I wanna tell you, I appreciate y'all's service in this. I know it's been difficult, but I do appreciate it, and I think I can say it on behalf of all the parties here, as well as the family members and the other people who've been involved in this case. When you leave today, if you'll give your jury books to my court officer here, we'll put those notes will be destroyed. Nobody will ever see those. Someone will take you back to the hotel and y'all can pack up and go back home. There is a possibility that you might be contacted by the press. If you are, what you'll do is you'll get an email from the clerk that says they've been contacted and want to know if any jurors want to speak to the press. It's only your call and you don't have to. You can just say no, and that's fine. If you want to, then he'll give you the name to call or something like that, but that's in y'all's decision as well. All right? It's been a pleasure to serve with y'all. Okay, thank you. Everybody rise, please. And y'all are excused. God bless you. So you have a seat, please. So counsel, what I'd like to do is take about a 5 or 10 minute break, then come back. We still need to schedule a sentencing hearing for these charges that were not the death penalty case. And then I also need to set a date for motions for new trial. I know we'll have to wait until the transcript is prepared. Do you have any, I know it's a long transcript, do you have any idea? You don't? Okay.
Maybe
Yeah.
set that date and sentencing.
Yeah, okay. We'll set the motion for new trial day on the sentencing hearing. Obviously, y'all got to file within 30 days, but obviously you get time to review the transcripts as well. So if we got to reset that, we do. So if you'll give me about 10 minutes, we'll come back in here. I'll bring my calendar and we can figure out when we can have the sentence. Anything else we need to do?
Yes, Your Honor. Have you made a ruling as the 13th juror?
On the what?
As the 13th juror?
I have not, but I will when I come back.
Thank
Is that
you.
okay? Okay. All right. See y'all in about 10 minutes. So ideally, I'd like to do the sentencing here within 60 days, but my October is kind of hectic. So with your permission, what I'd like to do is, I'd like to offer you either November 7th or November 12th. And if those dates don't work, I can give you some other dates.
I cannot do the 12th.
I can't do the 12th, I have a federal trial on the 12th.
How's the 7th look?
7th is fine.
I can probably do the 7th.
Judge, he said we don't have any time to do it.
Yeah, are you waiving my 60 days?
Oh,
Yes.
Yes.
Okay.
November
Is that okay?
Yes, sir.
Okay, so this, I'm gonna come back and visit y'all on November 7th if you've got a courtroom that I can use.
Okay.
And then we'll use this one in here, and that will be Finnegan sentencing. And so I think the way it's supposed to work is there'll be a pre-sentence report. And so whenever that's ready, if somebody could send that to me, that'd be great. And that'll be at 9 o'clock. And then I'm also going to sign this document saying that the juror questionnaires that we've obtained today, I think is today the 21st or 22nd? 20th? It's Tuesday?
Yeah.
Is it really? Okay. I've lost time. So it's the 20th, I'm going to sign this order sealing the jury questionnaires. And I'm also going to sign this order pursuant to the Criminal Procedure Rule 33D. The court accepts and approves the verdicts rendered by the jury, and I'm going to sign that for today too.
Now, Approach Judge,
Yes, sir.
transcript order?
Yes, sir.
Got
And
it.
then the
I'm gonna
state
fill the
gave
rest
me
of
back,
it.
the state gave me back their, the capital case form. If y'all hadn't done that.
Oh,
if
I've
you-
got it.
If you could just mail it to me.
We might need to work on this more.
I think I've got it.
Let's work on it.
Yeah, I've just a couple minutes to look through it.
That's fine. No rush.
Oh, I've got to put his work and stuff.
And let's see, let me go ahead and sign this verdict that I gave. I should make sure I get it like the one I signed. I don't need to make it
Let me see if the passport is in.
It is. You told me to. There you go, ma'am. And then here is the waiver. Do we need to make that an exhibit? That's the waiver he signed, giving up the right to testify.
That should be put in the charge.
Okay. There we go.
Okay, there's three. It's already marked two.
Oh,
It's
that's just
two.
your copy.
Yeah, this is already in.
Okay, you can keep it, or I guess give it to the clerk. It's not my
She's
copy.
not the original.
I thought that was the original.
No.
Oh,
the
this is my copy?
Uh-huh.
Doesn't look like,
Is the
know.
sticker on there or is
yeah,
it?
sticker's on there. It looks like the original.
Okay, then I have the copy if that's the case, but let me look.
Yeah, this has a real sticker on it.
Yeah. So that is the,
Maybe I got the copy.
Is this yours?
yes. I got it. So anything else for the state?
No.
Anything else for the,
Just real quick, Judge, I don't know the protocol on this, I'm not even sure if it's possible, but whenever probation comes to interview him, I'd like to be with him.
I'm not opposed to that at all.
They don't usually notify us of those things, so I'm not sure if there's a way for me to push a note to probation to have.
Why don't you notify
contact.
them that I asked for a pre-sentence report and I asked that you be able to participate in that?
Okay, because they won't notify me.
Yeah,
They'll
well, if
just
you'll
go
do
in.
that letter and just say I asked for it, that's fine.
All right, thank you.
Anything else? Okay, keep your seats. So I'm gonna let them do that. So we're gonna bring them in. I'll give them the admonition to be sure not to speak to each other about the case once they leave that room. Can't talk about anything till we all come back. Say about 9 o'clock in the morning, if that's satisfactory with y'all. Okay, you'll bring me in, please. All rise. Thank you. Have a seat, please. So it's my understanding y'all want to call it an evening. I certainly appreciate that and understand that. Had a long day today, did a lot of stuff, so that's fine. So they're delivering y'all's supper over to the hotel, so maybe it'll be there by the time you get there. But it's really important since we've done all this work and y'all have done fantastic, not talking about the case to each other. So please don't do that. Don't talk about your deliberations today or anything like that. And then we'll come back tomorrow with a fresh mind and be rested, and then we'll go ahead and get back in this and then hopefully get a verdict tomorrow. Everybody can do that for me? Okay. And so I hope y'all enjoy your evening rest. Take some rest. We all need some. Okay? All right. Everybody rise, please. All right. Y'all have a nice evening. Thank you very much. Statement, anything else from me?
No, Your Honor.
Anything else from y'all?
No, Your Honor.
So we're good? Going to the hotel? Okay. I'll see y'all tomorrow morning at 9 o'clock.
Yes, sir.
Thank you.
Thank you.
Thank you.